Welcome back, everybody, to our studies in land law, specifically our conversation on the issue of co-ownership. This lesson is going to carry on talking about severance, looking at the first method by which severance takes place as part of the Williams and Hensman list that identifies the various different methods of severance. This is called written notice, and is probably the most common, or one of the most common forms of severance. Of course, things like unlawful killing being one of the least common methods by which severance can take place. We'll talk about the first main method in this lesson, arguably the most commonly used method of severance. And we're going to begin with the Law of Property Act from 1925, because Section 36(2) identifies a little bit more information in relation to the idea of severance and the various different methods by which severance can take place. It says, and I quote, "Provided that, where a legal estate not being settled land is vested in joint tenants beneficially, and any tenant desires to sever the joint tenancy in equity, he shall give the other joint tenants a notice in writing of such desire." This is essentially giving us an indication of how severance takes place. Now, this is not the only method by which severance takes place, as we've noted from the previous lesson, but the Law of Property Act gives us an indication of how written notice is to be essentially understood through the process of severance. It's also a very nice way of understanding what severance means in this particular passage. It is talking about where you have a legal estate that is vested in joint tenants beneficially, and then you have a tenant who wants to sever the joint tenancy in equity. Remember, it can only happen in equity when you go from a joint tenant to a tenancy in common, since that this does not affect the process or the rights that exist at law. And then they go on to say that he shall give the other joint tenants a notice in writing of such desire. And so, written notice is a useful process for severance, since it does not require the consent of the other parties, in fact. So unlike things like mutual agreement and to a lesser extent mutual conduct, the idea of written notice doesn't require that everybody else has to agree to it. You can just say, look, I'm going to sever. I don't care if you want me to stay or not, or want me to remain as part of the joint tenancy or not. It is also a process which can be achieved unilaterally, so long as written notice is actually delivered in accordance with Section 36(2) of the Law of Property Act. Then it doesn't actually matter if, like I said, the other people consent to the process by which the severance is happening. They can unilaterally sever, and it's not up to the other joint tenants. We can illustrate the point of severance by way of written notice from looking at the 1969 case of the Draper's Conveyance. This case illustrates the format of a written notice. So, Section 36(2) doesn't really give us much in terms of how it should be formatted. It just literally says that he shall give to the other joint tenants a notice in writing of such desire, the desire to sever. Now, does this writing have to be by way of a deed? Does this writing have to be delivered by hand to the particular people? Does it have to be posted? If it is posted, does the postal rule apply in terms of severance? All of which are methods and questions that we need to think about. Simply put, it does not have to be a particular form. So it is actually quite vague and quite broad as to the extent to which written notice may apply. Nor does it have to say that it is written notice to be found in accordance with Section 36. So even if it doesn't say this is a notice to sever, even if it is just implied that this is a notice to sever, then this would constitute severance on the basis of Section 36 anyway. Written notice in question for this particular case was actually that of a court summons for an order for sale for a property that was distributed by somebody's wife. Her husband had died before the order had been granted, and so as a result of which the question of severance was at issue, whether or not severance had occurred. It had been held by the High Court that both the summons, in addition to the affidavit which was also constituted in relation to the summons, meant that it was written notice for the purposes of Section 36. And so for this particular reason, the wife had successfully severed from the property. So given the fact that notice needn't be in any particular format or any particular context, it's quite vague and quite broad as to what notice may actually constitute. It doesn't even necessarily have to say that this is written notice to sever. Who must therefore receive written notice? Who must be on the receiving end of the written notice? Well, notice can exist in many different forms, and simply put, the only requirement is the requirement that is cited in section 36.2, which is, of course, that the notice is made in writing. So who has to receive the notice? That's the next question. Well, the notice must be served to all of the other joint tenants in the property. So the people who have to actually get the notice are the people who are the other joint tenants. It must be delivered either personally or at their last known place or abode or business. Place of abode, or business. And so that's simply the only requirement in terms of receiving the notice. Where the severer has actually issued the notice in the post, there needs to be evidence that the notice has actually arrived. Now, this is quite interesting, because what this does is represent something of a shift away from what is considered in contracts as the postal rule. For those of you who haven't studied contracts yet, or maybe haven't gone on our lessons looking at contracts, the question here is relating to an offer and an acceptance in the law of contracts. You have an offerer makes an offer, and then the person has to accept the offer. If they have accepted the offer by writing and through the post, acceptance of the offer, and therefore the binding authority of the contract, takes place at the point at which the letter had been posted. And there are various different cases where a letter is posted, but then people go on postal strike, or it doesn't get received. It isn't received for another week or so, and then the person whose property, for example, they were selling to this person, then goes on to sell it to another person, and then the question is whether or not they breached a contract by doing so. The answer is so long as the letter was posted and was in the sort of system of the Royal Mail, that therefore means that the acceptance has taken place. Written notice in this regard, though, is a little bit different. Written notice doesn't require this. Written notice, in fact, requires a little bit more. It requires that there is evidence that the notice had actually arrived. And the case of Kinch and Bullard from 1998 gives us an illustration of this point. When notice to sever is sent by post, unlike the postal rule in contract, it is served at the point it is received, not at the point when it is sent and put in the letterbox. Again, this was a case which involved a notice to sever, as the rest did. The severer in question changed their mind before the letter had been opened, and so it was held by Lord Neuberger that notice was served at the point at which the notice was put in the letterbox of the receiver. And so the question of whether or not they were valid and whether or not severance had taken place is actually something of an irrelevant question, really, because simply put, after the notice had been, the letter itself had been put in the letterbox of the receiver, anything that happens, in this case the severer destroyed the letter, is irrelevant to this fact. Severance had taken place at that point.